And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
May it
Thank
please.
you very much. Good morning, everyone. My name is Amy Blake. Today I am joined by Justice Shin and Justice Maureen Walsh. We are the judges and the panel that will be hearing the 5 cases that are scheduled for oral argument today. Just so everyone is aware, it does proceed as if we were in the courtroom, meaning that each side is permitted 15 minutes of argument. There is no rebuttal. So with that said, let me call the first case, Commonwealth versus Donovan, docket number 19P877. Attorney Merrill, when you're ready.
May it please the court. I'm Dale Merrill representing Mr. Donovan. I think one of the important issues to bring out here is that the accuser, Gentry, had 2 stories about the puppy's ears being cropped. His first story was that when the puppies arrived in Salem, that the puppy's ears had all been freshly cropped. And it wasn't until the trial that he's changed, or until shortly before the trial, that he changed his story. And he said that he witnessed Mr. Donovan crop the puppy's ears in Salem. Now, his first story is consistent with that of the defense's witnesses, that the puppy's ears were cropped prior to arriving in Salem and that they were legally cropped. But this is a situation where, in the best light towards the Commonwealth, their evidence is inconclusive because their witness has changed his story. And this isn't one of
Yes, I do appreciate the argument. I understand. I read the transcripts, right? And I understand that they were very different stories at trial. But isn't it within the province of the fact finder, and here it was a bench trial, not a jury trial, to assess those credibility determinations? So although you have couched it in the nature of a sufficiency argument, really the sense I have, and I think the Commonwealth's brief suggests this as well, is that you just think that the judge should have believed your client's witnesses and not the government's witnesses. And I don't know that on appeal that's a proper issue for us.
Well, actually, the issue is more that their witnesses, the Commonwealth's witnesses, were inconsistent and it was unsupported. It still has to be a rational argument. It cannot be
unsupported. You said that they were inconsistent. I understand that, but you said that it was unsupported. What do you mean by that?
Mr. Donovan left the Commonwealth on November 2nd. The puppies were found on November 22nd. That's 3 weeks later. Their witness, the Commonwealth's witness, said that even a pinhole in the bags would have been sufficient for insect infestation. There was no evidence of what condition the bags were in because the Commonwealth had destroyed the bags. But they wanted us to speculate, and speculation is impermissible to support their position. So we have a situation where we have these puppies that are found 3 weeks later, and Dr. Blackmore, who was the Commonwealth's witness, who said she did not have any expertise in determining the life cycle of blowflies, maggots, the effect of freezing on the bodies. She said that a pinhole would be sufficient.
But that again goes to the weight of the evidence that the fact finder gives it, doesn't it?
Well, actually, I would say that's the evidence, the best light evidence that the Commonwealth has presented is insufficient, because they're saying that pinhole could have allowed
accident. Attorney Merrill, you and I both witnessed a car accident. A drunk driver hit somebody, and I testify that the light was green and you testify that the light was red. Somebody, the fact finder, is going to decide who they believe, right?
Correct.
Because it can't be green and red at the same time. So why isn't that the same analysis that we would apply here? You had experts that said this, you had experts that said that. The judge, as fact finder, weighs it and ultimately determines that your client was guilty.
This is not a case of A says one thing, B says another. It's a case of, A says something, and then A says something different. So it's the Commonwealth's witness. The Commonwealth never got over their burden prior to the defense putting on their case, is what I'm saying. It isn't a matter of the defense's position, I think, helped to deteriorate the Commonwealth's case. However, I think prior to the defense even getting to that point, the Commonwealth's case was insufficient because you have this expert, Dr. Blackmore, saying that she doesn't know anything about the infestation of animals. She cannot do any calculations about the death of the animals and when these occurred.
All right, so let me ask you this. Do you have a case that says if a Commonwealth witness is inconsistent in their testimony, that means the evidence was insufficient?
Actually, yes, and the Commonwealth, I believe, did quote a case to that effect. I'm looking right now for that case. I'd have to file a perhaps provide that to you later. I do have that here. And I believe it was one of the cases that the Commonwealth actually put together that actually talked about how their evidence had to be consistent. I'm looking at Commonwealth versus Pike, where they talked about how it was not a clash of the medical experts. The deterioration of the Commonwealth's case under Cater, which the Commonwealth quoted, had to be credible. But it cannot rest on conjecture. And basically their case has rested on conjecture that these animals might have been preserved in a bag. But the doctor was very specific. The Commonwealth's expert is very specific in saying that she looked at these animals to see if there was any infestation of blowflies. She looked at the mucus areas of the animals where blowflies would have accumulated. And she looked at these areas and found no blowflies. There was no odor. Chris Moran, who was the first person to open up the bags, stated that he did not smell anything and there were no insects. The police said they didn't smell anything when they saw the animals. There were no insects involved. And the Commonwealth's position has to be rational. You have to have a rational trier of fact, and I think that's a very, very critical issue here. It isn't rational to think that these dogs could have been dead in revere, subject to the elements and to scavengers, subject to raccoons, rats, seagulls, and thrown into a box of a pile of hydrangeas, of yard clippings, and yet not have had a piercing into those bags. So the Commonwealth is asking us to speculate, and their case cannot be built on speculation.
Can I ask you about a different part of your argument? Can you agree with me that when the judge spoke about the sufficiency in terms of the required finding, that he misspoke when he said Donovan, that he meant Gentry?
I'm not sure. I still think
when you read it in context, Donovan hadn't testified. It's the close of the Commonwealth's case. Commonwealth can't compel your client to testify. You can't agree with me that was a misstatement?
Well, we could also speculate that maybe what he meant was that what Gentry said Donovan said. We don't know what he meant. And then we have the other issue where the defense had evidence. They had a witness, and the judge allowed them to present these copies of the dog's ears having been cropped down in New Jersey. Yet we have an older defense lawyer who admits that he is having difficulty at trial, who failed to call the witness who he said he had sitting outside, and he failed to introduce the certificate stating that the dog's ears had in fact been cropped. And, this would have been conclusive evidence that the dog's ears had been cropped when they were in New Jersey, and yet he failed to present that, and he said he had that. So we have
without a motion for new trial below, we don't have an affidavit from the lawyer. We don't have the judge's ruling in terms of his observations of Mr. Atwood's performance at trial. We're really handicapped in that sense by the lack of a record below.
We do have the lawyer talking about how he needs to lean against the podium 3 different times. And even the Commonwealth turns and says, "Here, would you like to lean against the table here?" So that indicates that the Commonwealth is observing that this lawyer is in some physical distress. So while we certainly could have done a motion for a new trial, there is evidence in the record to show that this lawyer was in distress, and to show that he had other evidence he could have presented, which would have exonerated Mr. Donovan.
We don't have the actual evidence in this record, so how do we know that?
Well, you do have the defense lawyer saying that he is 72 years old and he needs to lean against the table.
No, but your ineffective assistance claim is based, at least this is how I take your argument, is based on counsel's failure to offer what you say is exculpatory evidence in the form of the vet records. But if we don't have the records themselves, how do we assess that argument?
We have the proffer of the trial lawyer stating that he has those records and that he has the witness there to testify.
Well, maybe he took a closer look at them later and decided actually they're not favorable. I mean, we don't know based on this record.
And we certainly could have done a motion for a new trial. I think it's really important assessing this case also and determining the reasonability to look at the timeline of this case, to look at, Mr. Donovan leaves Massachusetts. He doesn't return. Nobody says he returns. 3 weeks later, these dead dogs are found. They put this out on social media. Gentry, in fact, becomes the primary person of interest, but Gentry lawyers up. And then 10 months later, after Gentry kills Mr. Donovan's dog and Gentry's kennel is raided, and Gentry is under charges for having killed Mr. Donovan's dog and for the conditions of his own kennel, at that point, that's when Gentry comes forward with these stories against Mr. Donovan and tries to point the finger at Mr. Donovan. A rational trier of fact would have looked at that. It's very important to also look at the fact that Mr. Gentry has been given not immunity, but he's been given certainly consideration in terms of the kind of sentence that he was going to get for his testimony, and therefore his testimony had to be reviewed with very serious scrutiny. And when you have a situation where the experts are, the Commonwealth's experts saying she doesn't have the skills to go in and do an estimation of how long the dogs had been dead. The other experts are saying that the dogs could have been dead for only a day or two. It's pretty clear that Mr. Donovan was not in Massachusetts and could not have killed those dogs. So, we would say that there was insufficient evidence that a rational trier of fact could not have found that there was proof beyond a reasonable doubt that Mr. Donovan had committed these offenses. And even the light and the most favorable to the prosecution, even their story is insufficient to prove it. Some record evidence is not sufficient according to Jackson and Lattimore. Reversals required when the case is based on speculation or conjecture under Lopez and Combs, must have a solid foundation in the facts. It's speculation that the Commonwealth puts forward about whether animals could have gotten insects could have gotten into that bag because it was so tightly sealed. Again, the bag's destroyed, so there is no proof of how tightly sealed those bags are. The Commonwealth is asking us to speculate, and that alone is reversible error. Combs tells us that we need to rely on experience and common sense. We know how quickly, things rot and the smell that's emitted from them. That's what a rational trier of fact would know. And that under Combs can be applied, what a rational trier of fact, what experience and common sense tells us. And actually under Lopez, it says there's circumstances where it's impossible to reconcile the discrepancies. And this is one of those cases where it is impossible to reconcile the discrepancies.
Attorney Merrill, can I ask for one moment?
Sure.
Is your strongest argument, in your opinion, that the judge was not a rational trier of fact?
Well, that's part of the standard that has to be met. And I think that applying common sense and experience, we would all have to say that that was not a rational decision to come to.
Thank you.
Thank you.
I see that your time is up. Let me make sure the panel doesn't have any additional questions. Seeing none, thank you very much, Attorney Merrill. Attorney O'Sullivan, when you're ready.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. I understand from the panel's questions of my sister that the panel fully understands the Commonwealth's position with respect to both issues raised. So unless there are questions, I will be very brief. As to the first issue, the defendant's claim reduces to one that the fact finder, here a Superior Court judge, was required to discredit the eyewitness testimony at trial offered by Jason Gentry, both as to the ear croppings of the 4 puppies and as to the killing by hanging of the 2 named puppies, Livid and Gotti. That is simply a non-starter under our standard, under our directive verdict standard, of course, requires that all questions of credibility are reserved for the fact finder.
Well, can I ask you, your sister suggested to me that Pike and Cater perhaps stand for the proposition that inconsistency with a government witness could equate to insufficient evidence. Could you respond to that?
I believe my sister referenced my citation of Cater and the other case, which I cited, I believe, for the proposition that when a motion for required finding is made at the close of all evidence, the judges, or in this case, the judge, but the fact find or the judge, considering that close of all evidence motion, has to evaluate all the evidence and looks to whether the defendant's witnesses deteriorated the Commonwealth's case. As this court's decisions and the SJCs have repeatedly made clear, deterioration is not contradiction. You can offer contrary testimony, but unless the Commonwealth's case is proved conclusively false by the defense witnesses, that doesn't amount to deterioration. Neither Cater nor the other case stand for the proposition, as far as I'm aware, that the judge engages in weighing the evidence on a motion, either at the close of the Commonwealth's case or at the close of all evidence. I believe possibly the case my sister was trying to recall the name of, and I could be wrong on this, was one cited in her reply brief, which is the Lopez case. That is a 484 Mass 211 and that's a 2020 case. In that case, there were Commonwealth witnesses. There was a reversal on the basis of insufficient evidence. In that case, the Commonwealth witnesses were irreconcilably at odds with respect to their account of how this fatal beating and stabbing occurred, such that their testimony was irreconcilable with the physical evidence in that case, proffered again by the Commonwealth. And so that case does not stand for the proposition that there's weighing that goes on in the directed verdict standard. I could be wrong, and maybe we'll await a 16L letter on what case my sister was trying to recall, but that one was cited in her reply brief for the proposition that that the directed verdict standard involves weighing of the evidence. It doesn't, as this court and the SJC have repeated many times. With respect to the second issue, obviously our precedents disfavor strongly the raising of ineffective assistance claims for the first time on appeal, given that such claims are bereft of any explanation by defense counsel. And here, this claim is severely handicapped by the fact that we don't even have in the record the evidence that counsel says requires, the failure to introduce this evidence would require reversal. Obviously, the judge, who is fact finder in this case, has a right to pass on that evidence and can tell us, unlike in a jury trial, what effect that evidence would have had on his deliberations or his credibility determinations. That has not been done. So this is not part of the limited class of cases in which an ineffective assistance claim can be brought for the first time on appeal because the ineffectiveness appears indisputably on the record. So with that, if there are no questions, I would rest on my brief.
Let me check with the panel. Seeing none, thank you.
And we are back live and on the record.
Thank you. Again, good morning. Good morning, everyone. Again, my name is Amy Blake. Today, I am joined by Justice Shin and Justice Walsh. We are your panel for this case and the remainder of the cases this morning. The next case that we're going to hear is Commonwealth versus Robert Lee Anderson, docket number 20P1034. I do note that the case is partially impounded, so counsel, I'd ask you to comply with our impoundment rules. With that said, Attorney McVitie, when you're ready.
May it please the court. Mr. Anderson was arraigned on several charges at the time, and he was convicted. He was found not guilty of the armed robbery and the other charges, but he was convicted on the offense of intimidation of a witness. The basis of that charge was a police officer, Officer Bates, bringing Mr. Anderson from one room in the police station to the booking room. Mr. Anderson had a prior issues with this particular officer.
How do we know that, counsel? What's the evidence of their relationship? Is it just something we infer from the video, or is there actually some testimony to that effect?
It's not in the testimony. It's in defense counsel's plea at sentencing, where she's describing, granted, it's not evidence in the case, but it is in the documents in the sentencing argument of the defense counsel.
Okay, so as far as the evidence, all we have is the video and Bates's testimony.
Yes, and that testimony was that first, I would like to address the fact that the booking procedure is not a proceeding within the scope of the intimidation statute. That is a ministerial act. At that point, there was simply Mr. Anderson going from one room to the other, accompanied by Officer Bates. Officer Bates was not part of the investigation.
Let me interrupt for a moment. Do you have a case that supports that proposition that the booking process is not part of the criminal investigation / proceeding?
No, I don't, Your Honor. I think that what is occurring with this statute is it's trying to be all-encompassing. And if it is a part of this statute, then I would argue that the statute is vague and unconstitutional, because a person being booked would not believe that a police officer taking them from one room to another, that if they became agitated like Mr. Anderson because he was innocent of the charges, that they would be charged with an offense that carries up to 10 years, and in Mr. Anderson's case, 20.
Let me interrupt you for a moment. Would you agree with me that if Mr. Anderson from the room to room transfer said to Officer Bates, if I give you $10,000, will you let me go? Would that fit within the meaning of intimidation of a witness / law enforcement?
No, because he's not part of the investigation and it's not a proceeding. It's a separate crime, but it's not under this statute. This statute is broken into two parts. One is intimidating a witness, or one is an investigation, and the other has to do with proceedings. Officer Bates in the armed robbery case was not a witness. He was not going to be testifying. He was just simply taking Mr. Anderson from one room to another room.
I'm not understanding this argument, this particular argument, because the jury were instructed on what a proceeding is, and they were instructed that it's some step taken before a court. So I don't think the question before us is whether the booking procedure itself is a proceeding, but rather whether his conduct he should have known that it was going to delay some future proceedings. So I think we're talking about the arraignment, at least as far as the jury was instructed.
Exactly, and there was no delay in the arraignment.
But there doesn't have to be a delay. So I mean, the question is whether he acted with reckless disregard of the possibility that a proceeding will be delayed. We're not talking about the booking procedure. It's a court proceeding. That's in the instructions.
Well, then my argument would be that that's not an appropriate, you're asking jury to speculate as to what the proceeding is that's being delayed. And the facts that came out in the case were clearly that no proceeding was delayed and that it never would be delayed because the booking, he was arrested at 2 o'clock. He wasn't going to get to an arraignment until on a Friday. He wasn't going to get to an arraignment until a Monday. Those facts don't support the booking, his meltdown at booking being an offense that carried 10 years, at least 10 years, 20 years if they do the enhancement. And an ordinary person wouldn't believe that that would be true. So if the court finds that this booking procedure was within the scope of the statute, then the statute is vague and up to arbitrary and discriminatory.
Let's say that we agree with you that there's not enough evidence to show that he had the intent to delay. Why doesn't his conduct fall within the second clause of the intent element, which is to punish, harm, or otherwise retaliate against any such person for his participation in the proceedings? Why isn't it retaliation to say, why couldn't the jury find that he was threatening to spit in the officer's face because of the officer's participation in his arrest?
Because the evidence that's before you, what was the evidence that was before the court was Mr. Anderson's saying that he was being set up and that it wasn't that it had nothing to do with the investigation of the robbery case. It had to do with his knowing that he didn't do it and he was being arrested and he was very angry. But it wasn't to prevent the police officer from testifying. because he wasn't going to be testifying. He wasn't a witness. This is a statute to protect witnesses and investigators, not an officer who's taking someone from one place to another. That is outside the scope of the witness.
I mean, the statute is, sorry, I'm getting some feedback. The statute's written much more broadly than that, at least as I read it. So let's say that the defendant said to Officer Bates, if you don't drop these charges against me, when I get out, I'm going to come to your house and kill you. Why wouldn't that fall within the statute?
Because it's a separate crime. You know, if everything that happens from the thought of the crime to way after the crime, the way that the scope that the Commonwealth is advocating, then it's way too broad. You know, anyone who's being booked.
But Attorney McVitie, the case law says even after a verdict, you can be charged with intimidation of a witness. So it is already accepted that this is a broad statute. But on the facts, on the hypothetical that Justice Shin just provided, in the booking room, he says, if you don't drop these charges to Officer Bates, I'm going to hunt you down and kill you. You're not conceding that that would fit within the statutory scheme of intimidation of a law enforcement officer? It's not just intimidation of a witness.
But it's someone who's going to testify. It's someone who, you know, you have this crime, and that's just like saying, let's say he's not in a booking room. Let's say he's outside and he doesn't like the officer and he says, you leave me alone and I'll do something. It's not attached to a crime. What I'm saying is, for this to be constitutional, whatever occurs has to be within the crime that's being alleged.
So Attorney McVitie, if he said to a witness, if you don't drop the charges, the victim, then I'm going to go out and kill you.
Absolutely, that he would be charged, because it's a victim. It's someone who's going to be testifying. It's someone that this.
The statute is plainly not limited to someone who's going to be testifying, because the categories of persons to which it applies includes a clerk, a court officer, a court reporter, a court interpreter, right? So it cannot be just somebody who is going to testify. The statute's much broader than that.
It is. It's talking about a proceeding. A clerk is part of a proceeding. All these people are part of a court proceeding on what is charged.
Can I ask you a totally separate question? What is the status of the case before the appellate division?
Well, the sentencing, I just heard from the attorney, the Superior Court attorney, that the sentencing appeal is in November.
November. Thank you.
So the statute, should the court find that the statute is encompassing anything that happens in the booking room, I would argue that this that is unconstitutional. I also would like to go back to just the statutory interpretation, going to Escobar, that the booking is not doesn't have the characteristics of the other mentioned in the case, the statute, that it doesn't have the same characteristics as any other criminal proceeding. But should the court find that the booking process, the ministerial process of booking a person, is within that scope, then this statute, as interpreted, would deny the client due process and equal protection, because the booking process, an ordinary person would not know when he was being booked that his behavior would come under this statute. It's a booking, it's a ministerial process, and that it is subject to arbitrary and discriminatory application. One of the things that they found, I did cite the study that was just done that the court, I believe that the court asked for, showed that the charging decisions of the Commonwealth lent itself to disparities, and that Black defendants were discriminated against. At least that's preliminarily what that study showed. The study is rather incomplete because they don't have information from the district attorneys as to why they make the decisions that they make. But this, whether or not to charge someone for their behavior in booking, could be found to be arbitrary and discriminatory. In particular, in this case where he's being arrested for armed robbery, and then they have this second charge, which arguably has nothing to do with the armed robbery. It has to do with the client's dislike of this particular officer. And that goes to my argument that it shouldn't have been joined at trial because it doesn't have any,
Why don't you finish your thought?
Okay. It doesn't have the same characteristics that joinder would have. That would be my argument.
Let me see if the panel has any additional questions. Seeing none, counsel, thank you very much. Attorney Kohler, when you're ready.
Thank you, Your Honors. Good morning. May it please the court. Carrie Kohler for the Commonwealth. I think I set out the majority of the Commonwealth's argument better in my briefs than I will here this morning. But I would like to address one point that my sister made about the nature of the threat. I would suggest that it is connected to the offense based on just the substance of it. It's not simply, I'm going to spit on you. The actual quote is a bit vulgar, but it is directing the officer to stop communicating with the.
Can I ask you about that?
Yes.
Sorry to interrupt you. I think
Of
I'm
course.
going to have a lot of questions for you. I'm just warning you in advance. I know that's
Okay.
exactly what you want to hear. How is a threat to spit in your face a threat to cause physical, emotional, or economic injury? The statute's not limited to threats generally. It has to be a specific threat to cause injury, physical injury. So how is spitting in someone's face a physical injury?
I don't think it is. I think this fits more in the harassment section of the statute.
So let me ask you about harassment.
Yes, sure.
Okay, so harassment is defined in the statute.
Yes.
And it requires an act directed at a specific person. I think we have that, but that seriously alarms or annoys such person and would cause a reasonable person to suffer substantial emotional distress. So what's the evidence that his threat to spit in his face caused Bates to be seriously alarmed or annoyed? He didn't look alarmed or annoyed on the video to me.
Right. Well, I think the statute and the case law make it clear that the actual target, the victim, doesn't need to be seriously alarmed, injured, annoyed, whatever the statute's describing. But I would suggest that.
Well, I'm not understanding that answer. The statute expressly defines harass.
Yes.
as an act that causes the person to, is an act that seriously alarms or annoys the person. Right?
I was looking at the second part. I should address your first. I should start in order, shouldn't I? I'm sorry.
So my question is, what's the evidence that Bates was in fact seriously alarmed or annoyed?
I think you can infer that from the threat. I don't think there is direct evidence in the video or in the testimony. I concede that. But I think even under society norms, that is a seriously alarming and distressing thing, to have someone threaten to spit in your face. I think that is not only incredibly disrespectful, but potentially dangerous. And the record isn't clear about that, but I think that's a reasonable inference where somebody is.
Doesn't harassment in the cases normally arise in the context of some repeated conduct? That's how I understood harassment. And do you have a case that says something similar to this is harassment?
No, I don't. And I understand Your Honor's point. I think it's a fair one. I think harassment, as we see it in other kinds of cases, domestic violence case, a case where friendships dissolve or there's animus between two parties, harassment's a little bit clearer. And I think it's a little bit more complex in this particular case, as far as harass is concerned. I think, and I'm looking towards my side, I'm looking at the statute. I think here, as we read through harassment, I think the Commonwealth, satisfied its obligation to prove that you have this action of the spitting in the face directed. I would submit to the court that the act or the threat of spitting in someone's face is seriously alarming and annoying, and I think that can be inferred from the conduct itself. I don't think it would have been nice.
But would you agree that the statute requires evidence that the person was in fact seriously alarmed or annoyed? Would you agree with that?
I think so. I'm unaware of a case that says anything differently than that, and I don't think there's any reason to interpret the statute differently. If I'm wrong, though.
Before we get to the question of intent, then, to find the qualifying act, your position is that we need to find that the defendant's conduct falls within the definition of harassment. Is that what you're hanging your hat on, is harassment?
No, I would also, I make multiple arguments, and I think you can say that it is a threat as well. I think that.
But how is it a threat? So going back to my first question,
sure,
how is it a threat to cause physical injury or emotional injury or economic injury?
I'm just going to cross out, I just had written Commonwealth concedes that it's not a threat.
No, and I might. It might make sense if I'm wrong about that. And I struggled with it. I don't want to back away too far from the argument, but I mean the court has, Your Honor has a point, and I understand it. I'm now struggling up the hill, and I recall this when I was working on it. That is a very difficult section to grapple with, and it leads to difficulties. I would agree that the act of spitting does not lead to the physical injury. I would agree with that. If it's not, I mean, as far as
it's not, if it doesn't fall within little Roman numeral 1 as a threat, it's not a bribe, which is little Roman numeral 2. So under 3.
No.
So 3 is misleads, intimidates, or harasses, and you're saying that falls within harass.
Yes, I would just like to go back to the threat for a moment, and I think as I read it when I was preparing, and I don't think I found any case that said a threat has to explicitly be something that causes the injury. I was breaking into a list of distinguishing things and not like things, and I don't know if the case law, because I didn't really, I didn't look at it with that close an eye with that particular lens, whether the case law says threatens attempts or causes, right? But I think as I sit here now and listen to Your Honor's question, that is a fair point for me to concede here. And did I answer Your Honor's?
I appreciate your candor in that regard. That this is a tricky case, and I have to say, the video was underwhelming. I mean, because I'm trying to look at this in context, and you know, I was excited to get the video because I thought this is going to put it all together for me, but it really didn't. What do we know outside of your sister says at sentencing it was raised about the relationship? Is there anything in the trial testimony or the evidence itself about the relationship between this police officer and this defendant?
No. I believe there might have been some testimony from the defendant where he talked about being aware of Officer Bates. I think he said he'd seen him around on Mass Live and knew that he was a warrant apprehension detective. But I believe, to the best of my recollection, that's the limits of his testimony. He doesn't talk about an ongoing relationship. He doesn't talk about other incidents, episodes, fights, arguments, or even feelings. Bates is
not asked about it.
I'm sorry?
Bates is not asked about it.
No, the prosecutor does not ask Officer Bates about that. I will say, I see Your Honor's point about the video, and I don't know if this is a case about contextualizing these two people with one another. I think on this record, they don't have a relationship with one another, and the only information about them having any kind of relationship comes after the fact from trial counsel, and I'm not aware of any relationship between them.
It seems pretty evident to me from the video they have some existing relationship, because you know, he makes the threat to spit in his face pretty soon after he's brought in. Yeah. And then the booking officer says, "What's your name?" And he very politely responds and then turns back to Officer Bates. So, I mean, there's definitely something there. So if we were to get to the question of intent, I mean, what are the limits on this? I found this really tricky because I think under your theory, let's say that when the arresting officers come to arrest the defendant, and I understand that Bates wasn't part of that, wasn't an arresting officer. Let's say when they come to arrest him, the defendant had said, if you put those cuffs on me, I'm going to punch you. Under your theory, that would qualify as witness intimidation because the arrest is part of the investigation and he's making the threat in order to delay the arrest, right? But we have a separate statute that governs that precise situation with a maximum penalty that's much lower, I believe, than this statute. So what are the limits on this?
I don't know. I think as applied to this defendant, I don't think we hit the limit. And I agree the record is somewhat convoluted as to how Mr. Anderson comes to be at the police station. I think that's a fair thing to say on this record, because you have Officer Bates who seems to be, based on the record, transitioning the defendant from outside to inside, and it's not really clear how he came to be in police custody. And I am constrained by what the record evidence is as far as that.
So I understand that. I just, this statute can be read so broadly that it seems to encompass situations that the legislature wouldn't perhaps contemplate. And when going back to Justice Blake's comment about the video, when I watch the video, I see a defendant who mouthed off for about 30 seconds to an officer that he has some sort of beef with. It seems very clear to me on the video. If he had said, shut up or I'm going to kill you, I don't think we'd be here. I mean, that's not something that he could have, that would just be him mouthing off, right? And so I see a defendant who mouths off for 30 seconds and then gets a 6 to 8 year sentence in state prison. Is this a situation you think the legislature contemplated when it enacted this statute?
I think here there's a little bit more than just the defendant mouthing off. You have Bates interacting with Officer Zanzanian, and you have them not just communicating with one another, but exchanging information. And you can see in the video that Officer Bates is holding a piece of paper, that he's referring to it, that the sergeant is communicating with him, that he asks him something. And then the officer comes closer around, and you can see that. And I think you also have the statement from the sergeant that to the defendant addressing, I believe he asked a question about why he still had to be here. And the sergeant responds, he's here in case I need him to, he's here to answer any questions I have for him. I mean, he's also the sergeant, so I guess if he says Bates can't leave, he can't leave. But I think that there shows more interplay than what we'd see in a typical booking video of the arresting officer or the escorting officer sitting by waiting for the boss to say, be on your way, we're done here. Bates and the sergeant have an interaction, and he is facilitating this process. And I think when you look at that in connection with his conditional threat, I think there you have the harassment. And that's what I think the Commonwealth hangs its hat on. I agree with
Let me go back, Attorney Kohler.
yes.
You're conceding it's not a threat. You're agreeing that Bates does not appear on the evidence of the video, either seriously annoyed or alarmed. But your argument is that the conditional threat meets intimidation.
Yes, and I would say that he doesn't have to be seriously alarmed or annoyed. I would suggest that that's a reasonable inference from the context of the threat. And I think that it would be more, I wish I had a clearer record, I do, but I think it would be fair to assume that an officer is not expected to lose his cool under a threat from an arrestee, and that we would
You read intimidation to encompass a broader category of threats or harassment than what's previously defined in the statute. If intimidation is that broad, it basically means threats and harassment. That it's almost superfluous then.
I don't know if I'd agree with that categorization, but I think if I could just finish my thought, I see my time's expired.
No, please finish your thought.
Thank you. I think that, and it was mentioned earlier, that it's not just about witnesses or potential witnesses. It's about police officers and investigators who are different, you know, and they're specifically listed. It's also about court personnel. And I think that when you look at that category, those categories of persons, we expect those people, lawyers, judges, clerks, police officers, investigators, to behave a certain way, even when confronted with threatening, harassing behavior. And so I think here, we don't expect Christopher Bates to lose his cool, and he doesn't. But the context of the threat would be seriously alarming and annoying. And I thank you for letting me finish my thought. May it please the court, I'll rest on my brief.
Let me check and make sure. I know Justice Shin had a bunch of questions for you. It looks like we're all set. I want to thank both counsel. This is a very tricky case, and you both record. I am Amy Blake, and I'm sitting today with Justice Suk-Young Sheng and Justice Maureen Walsh. We are the panel for this case and the remainder of the cases that we'll be hearing this morning. Our next case is Commonwealth, versus AAREN Howard, docket number 20P0937. This is the Commonwealth's appeal. So Attorney Armstrong, when you are ready.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. I would also like to acknowledge the motion prosecutor, Assistant District Attorney Nathan McGregor, who is watching this argument via the live stream. This court should reverse the motion judge's suppression order suppressing the evidence found in Mr. Howard's car because simply she erred in concluding there wasn't reasonable suspicion to stop the car. And that was an error because there was probable cause, not only reasonable suspicion, but probable cause to arrest the defendant based on all of the facts that were known to Officer Conley at that time. And even more than that, after the stop of the car was effectuated and the defendant resisted getting out of the car and attempted to flee in the car, that justified the search incident to his arrest of the bag that was in the front passenger seat of his car. So specifically with respect to the probable cause to arrest the defendant, at the time Officer Conley saw the defendant walking to his car, he knew that he had seen the defendant on Snapchat 2 to 3 times posing with a gun. Most relevant to this inquiry was the night before, about 18 hours prior, he saw the defendant on Snapchat posing with a gun with a caption that said, "New toy alert for a new beef," with the geocode being in Dudley Square in Boston.
Attorney Armstrong, it seems that you have somewhat, I'm going to say, altered or morphed the Commonwealth's argument on appeal from what was argued below.
From the initial motion to suppress, that's correct, Your Honor. And then following the motion being allowed, the Commonwealth filed a notice of appeal and filed a motion to reconsider, articulating this argument, which I was just going through, that there was probable cause to arrest the defendant, which entitled the police to stop the car. And then based on...
And is it your view that the single justice allowing you to proceed cured any defect in the notice of appeal or the argument on appeal?
Yes. Simply
and what
put,
do you
yes.
rely on? Is that by rule, by case? How do we get there?
Sure. So I would rely primarily on Commonwealth versus Jordan, which the single justice referenced in allowing both of the motions. And also, I don't believe
Jordan only concerns the timeliness of the interlocutory appeal, right?
As opposed to the substantive.
Right, as opposed to looking behind the papers and resolving any questions of waiver. I mean, I don't think that's what the single justice does.
No, that's fair. And Jordan does kind of articulate what the timeliness aspect is. With respect to the substance of the argument, I would rely on, and I cite it in my brief, Commonwealth versus Rodriguez, 443 Mass 707, for the authority that an issue raised for the first time in a motion to reconsider can be considered by the appellate court. And that it does say that provided it's filed within the time period allotted for taking that appeal, and any deficiency for our motion to reconsider being filed 5 days after the 30-day timeline, I believe would be cured by the single justice's order, specifically allowing the motion to reconsider to be timely filed, as well as the Rule 15 application being timely.
Rodriguez and Kronk, which is the other case, those cases concern both timeliness and jurisdiction. In other words, the issue in Kronk was that the trial judge didn't have the jurisdiction to act on the motion to reconsider because the appeal had already entered in the appeals court. I mean, that's a different question. I think the problem here isn't so much timeliness or jurisdiction as it is waiver.
Well, I think it would be different had we not filed a motion to reconsider and pursued on this theory exclusively on the Rule 15 application. And had we done that, I would agree that that argument would not be preserved because it wouldn't have been considered by the motion judge. Here it's different because we filed the motion to reconsider. The defendant filed an opposition to that motion and the judge considered it. Even though she endorsed it with a one-sentence endorsement denying the motion to reconsider, the judge still had the ability to review that argument, compare it to the facts, and then make a decision. And she denied it.
She denied it for the reasons stated in the opposition, which included that it was untimely. that the argument was raised too late after the evidentiary hearing.
Correct, but back to the timely issue, any issue with that is cured by the single justice's
Okay,
allowance.
I shouldn't have said timely. I mean that the argument was raised after all the testimony had been taken and the judge had ruled.
Well, and that's I believe that's totally fine, because on our appeal now, we're not arguing against the facts that are found by the judge. Based on the facts found by the judge, this court, you all could use those facts to look at those facts to determine that there was probable cause to arrest the defendant for illegally possessing a firearm, and then justify the search incident to arrest after the fact.
How do we have enough facts to justify it as a search incident to arrest? Don't we have to know the timeline of what happens?
Well, I believe you can look at specifically the judge's factual findings show that it occurred close in time. The judge's specific facts about the search incident to arrest are on page 62 of our appendix, and said, after the defendant was removed from the vehicle and placed under arrest, Connolly opened the brown satchel, found bags of marijuana, a firearm, and ammunition. That's supported in the record at transcript page 49 and 50. And even more, when you look at Officer Connolly's specific testimony on page 50, he says he looked in the bag, saw the evidence, then after he looked in the bag, the defendant is placed in the handcuffs. Even more than that, on cross-examination at page 81, Officer Connolly says it was within a few moments with respect to the search after the car came to a stop. It was within a few moments, pretty soon after they removed him from the vehicle, and I was seated in the front seat. So Officer Connolly, in order to get Mr. Howard out of the car, Officer Connolly had to roll over to the passenger seat, sit down on top of this bag, get out, and then open it. And all of that happened, you know, according to the judge, it happened after. But when you look at Officer Connolly's specific testimony, it happened right around the same time. And even more than just the contemporaneous argument, which, would be kind of under the Pierre or the Chimmel analysis, based on these facts, there's probable cause to believe that that gun was actually inside of that bag. So when you look at all of the facts.
How is that?
Sure. So the facts that support probable cause to arrest him for the completed crime of possession of a firearm, the fact that he posted with a gun on Snapchat, the caption being.
How is there probable cause that it was in the bag?
That fact that he has the gun, the fact that he's on Snapchat posting new toy alert for new beef, creates a reasonable inference that he's going to be using or carrying this gun for personal safety because of the new beef. So he's going to have it with him. The fact that he is inside of the car posing with the gun, the fact that police have seen him 2 to 3 times additionally on Snapchat with the gun, and the fact
Attorney
that
Armstrong, how do we know that the bag is related to, so if there were 5 bags in the front seat, 5 different containers?
Sure.
There's no connection with this satchel.
No, and 5 bags would be certainly different. However, in this case where there is 1 bag, I think, and the last fact, I'm sorry, Justice Walsh, the last fact that I wanted to establish the probable cause that evidence related to the crime would be found in that bag is when the additional officers arrive, Officer Connolly requests the defendant to get out of the car. He, in response, resists that, closes the door, and puts the car into drive to drive away. That is consciousness of guilt. That gets us over the hump to establish to probable cause that the gun is in the car, which entitles the police to search that bag, incident to arrest, and that would be consistent with Arizona versus Gant, Thornton versus United States, and those line of cases.
Is your proposition that because the defendant evaded the police, that they could search the entire car, including the trunk and its contents?
That would not be
limited to, or is it limited to that satchel?
I would limit it in this case to that satchel, because Officer Conley, in getting out of the car, got over the defendant onto the passenger seat and only looked inside that bag.
So the first justification for a search incident to arrest, which you've alluded to, is that it is likely that there's evidence of the crime of arrest in the car. Doesn't
Correct.
that presuppose that the defendant was actually arrested for that crime? I mean, that's not what happened here. You're saying that you can come up with a justification after the fact. So we just kind of disregard what actually happens?
Well, no, because the crime of arrest, here being possession of a firearm, that is the reason that they're arresting him. So the evidence
No,
of the
it wasn't. It was what transpired after the officer got into the car, and then the defendant, a defendant didn't really have control over the car, but that's why he was arrested, because he didn't step out of the car.
well,
So then the firearm wasn't found till later. He was already arrested at that point.
well, that is one interpretation of the judge's findings, but he could have also been arrested based on that probable cause that he.
Right. No, that's my question. Is you're saying he could have been arrested, but he was not in fact arrested. And to me, when Gant talks about evidence of the crime of arrest, it presupposes that he was in fact arrested for that crime. Do you understand my question?
I don't totally follow, because he was placed under arrest at some point after he tried to flee. The car moved over in the traffic lanes. The car comes to a stop. He's removed from the car, and within a short period of time, the bag is opened and searched. Them placing him under arrest for assault and battery with a dangerous weapon vis-a-vis the car, or for the illegal possession of the firearm that evening. I guess I understand your point now. I think the police had probable cause to arrest him based on the Snapchat video the night before, absent a firearm being in his possession that day. So had the police just pulled him over and Mr. Howard had not resisted, for example, and gotten out of the car, and the police placed him under arrest, I don't know if there would be probable cause to search the bag in that moment, because there's nothing tying that bag to the criminal activity of which he is suspected of participating in, namely possession of the firearm. However, when he resists, based on all of those facts that go to the illegal possession of the firearm, transfer over into his consciousness of guilt and closing the door, putting the car in drive, and attempting to flee. That creates the probable cause that there might be evidence related to the crime under which the police are investigating, i.e. possession of a firearm inside of that car, inside of that bag.
I find that troublesome, because the judge found that what in fact happened was not lawful. And so had they in fact just arrested him, pulled him over and arrested him right away for the unlawful possession of a firearm, you're saying that, there might not be a search incident to arrest exception applicable, but because of what transpired, him pulling him over for this traffic violation, which the judge said didn't actually happen, then stalling and calling for backup, it's this series of events that caused the ultimate arrest. So, I just find that troublesome.
Well, and I understand, Your Honor. I think the issue is that the judge viewed this in the reasonable suspicion context in isolation and stopped there. And that our contention is that is an error of law. When the police had probable cause to arrest the defendant based on the video in conjunction with him not having a license to carry from the night before, that allows them to pull the car over absent any traffic violations. And then that, in conjunction with the defendant's consciousness of guilt and attempted flight, generates the probable cause necessary to get inside of that bag to look for evidence of the crime in which he has already committed, i.e. possession of a firearm. I'm seeing that my time has expired.
Let me just see if the panel has any other questions.
Just one on a fundamental fairness, Attorney Armstrong. To me, I sense an argument that was made a judge who made a decision, and then the appeals division saying, why didn't you argue this? So had the record been developed and the argument been presented, you would have been in a different place here today. But it seems to me that out of fundamental fairness, the Commonwealth had its shot. It didn't develop the record and it didn't make the argument, and the judge ruled upon the facts that were before them.
I completely understand Your Honor's point, and I have just two very brief responses. The first is that was why we attempted to pursue the motion to reconsider at the motion stage, to give the judge the opportunity to review that theory, apply it to the facts that she had found, and reconsider her ruling. She also had the ability, which is my second point, to, if she wanted to pursue that theory or expand the record, she could have ordered an additional evidentiary hearing. Similarly, this court has before, and could in this case, if you're unsatisfied that the facts don't support probable cause or reasonable suspicion, you could remand for a new evidentiary hearing to reopen the record.
Thank you.
Thank you.
Thank you very much. Attorney McDonough, when you're ready.
Thank you, Your Honor. Good morning, Honors. May it please the court. My name is Jaleese McDonough and I represent Mr. Aaron Howard. Today we're asking the court to affirm the trial court's order suppressing all evidence in this case. I'd like to cover all three of the overarching arguments that the parties have made in the brief. So the waiver issue, whether this was a valid search incident to arrest, and whether there's actually probable cause to arrest someone based on a Snapchat video alone. So one thing I do want to point out at the outset is that the Commonwealth has kind of now shifted back to some of the arguments they made in the trial court but did not raise in their brief. So down below, the Commonwealth did argue that there was potentially the officer was allowed to search the bag based on the assault and battery with a dangerous weapon for Mr. Howard allegedly attempting to flee in the vehicle. They abandoned that argument in their brief and argued solely on the basis that this was a search incident to arrest because of the firearm the night before from the Snapchat video. So I would just contend again that now the arguments that they abandoned, that they raised below, are now waived for this court to review. And the sole issue before this court is whether the search was justified incident to arrest for arresting him based on the Snapchat video from the night before. And we are raising a timeliness issue. We raised it in opposition to the motion to reconsider. And as Your Honors pointed out, the trial court did deny the Commonwealth's motion to reconsider based on all of the arguments raised in opposition. But further than that, our main argument is that it's unwarranted to raise a new issue after the evidentiary hearing. It's unfair. The Commonwealth has argued that the record was sufficiently developed, but we're arguing that it wasn't sufficiently developed. There was a number of questions I would have asked if we were on notice prior to the evidentiary hearing that the Commonwealth was raising that this was a search incident to arrest based on the firearm. The timeline was not sufficiently ferreted out. We would have asked, where Mr. Howard was in conjunction with the vehicle, whether there were officers on top of him at the time that Officer Conley searched the bag. I don't think it's out of the realm of possibility that the 4 officers who went and pulled him out of the car would have immediately threw him on the ground, given that they believed he just fled with an officer in his vehicle. None of those questions were asked because the Commonwealth did not raise this issue. Also, Officer Conley did testify that he pulled he got out of the vehicle and then grabbed the bag and looked in it. So at this point, presumably, Officer Conley is standing on the opposite side of the vehicle. Mr. Howard is already on the ground, placed in handcuffs by 4 police officers at the time of the search. Officer Conley testified at page 49 through 51 that 4 officers caught up to the vehicle and removed Mr. Howard. And then it was at that time that Officer Conley rolled over to the passenger side of the vehicle. I got out, I opened the satchel that was sitting next to him, and I observed the firearm. And he said that as soon as the car stopped, Officer Conley's partners pulled Mr. Howard out of the vehicle, and that he searched the bag after that. So presumably at this point, Mr. Howard is already out of the vehicle on the ground with 4 officers. We don't know whether he's in handcuffs and things of that nature, but at that point, it's not in Mr. Howard's immediate control. He's under arrest at this point. It's not within his wingspan, where Officer Conley should be alarmed that he could reach back into the vehicle and obtain a firearm to either aid an escape or to destroy evidence. And as far as the motion judge's findings, there's a couple of key findings that the court found that the Commonwealth doesn't seem to say are erroneous at this point. At the Commonwealth's appendix, page 62, the court found that Howard was already removed from the vehicle and placed under arrest when Conley removed the brown satchel. The testimony that I just went over supports that finding, and the Commonwealth has not alleged to any degree that that finding was erroneous. The Commonwealth's appendix, page 60 to 61 and page 64. The court outlined several factors that she relied on to determine that there was no reasonable suspicion to believe that Mr. Howard was in possession of a firearm when they observed him on July 3rd. She points to the fact that Mr. Howard walked to the vehicle. He did not look around. He did not touch his waistband. He did not in any way suggest that he was carrying a firearm at that point. The Commonwealth seems to argue that because it doesn't seem there's a firearm in his person, there must have been a firearm in the bag, but there's many inferential leaps to get there. Mr. Howard clearly had been in his home for at least 3 or 4 hours by the time the officers saw him leaving the house. There's nothing to suggest that that bag, as your honors have noted, was in any way associated with this firearm. During the video, you don't see the bag. He doesn't pull the firearm out of the bag. He doesn't put the firearm in the bag. The bag has nothing to do with the firearm at the time that they see him walking to the vehicle. Once they stopped Mr. Howard, he's polite, he's cordial, he's not hyper-focused on the bag, he's not touching his waistband, he's not doing anything to suggest that he's armed at that point. The only time he seems to get nervous is when 4 officers get out of the car and start to approach. And even then, Officer Conley admitted that he said, you know, it's July 4th, we have more officers than usual out, and Mr. Howard immediately calmed down again. It wasn't until Officer Conley pulled open his door and told him to step out of the vehicle that he became nervous again. And the trial court clearly found that all of the actions that happened after that were precipitated by the officer's actions, not by Mr. Howard. So to suggest that that somehow escalated into probable cause to search the bag at that point because of consciousness of guilt is not supported by Officer Conley's testimony. And as far as, our point would be that there was no probable cause to search the bag. It was not a search incident to arrest because Mr. Howard was already out of the vehicle and the bag was not in his wingspan. And we would contend that there wasn't even probable cause to arrest him based on possession of a firearm at the time of the stop. There's very limited case law on this issue out of both this court and the SJC. The 2 closest questions, I think, are Commonwealth versus Watkins and Commonwealth versus Orion O. They're both, Watkins is a published, Orion O is an unpublished decision. In Orion O, this court found at most there was reasonable suspicion to investigate someone based on possession of a firearm. And in that case, the stop occurred almost immediately after the video was posted. The officer encountered the 2 gentlemen in the exact area that the video was posted. He was wearing the same clothing. He was clearly a juvenile, so the officers were able to tell that he was not able to possess a firearm. And as soon as the officers called out to him, he touched his waistband. So there was also indicia that he was armed at that moment to support the Snapchat video. Here we have a stop 18 hours later where Mr. Howard is in no way suggesting that he's armed. So essentially under the Commonwealth's argument, the police would be able to stop him in perpetuity based on this one Snapchat video, or even if you believe that there were other videos of him with a firearm because of the Snapchat videos without any indicia that he could be armed at the time of the stop. Commonwealth versus Watkins, the police officers were able to determine that it was a live working firearm at the time of the video. They saw the firearm, they knew it was a TEC-9, which was a particular gun that they had familiarity with. He was holding a large capacity clip separate from the gun and actually put it in the gun during the video to suggest it was real. And there was live ammunition depicted with the firearm. Here, the only thing Officer Conley was able to point to suggest that he thought it was a real working firearm was that there was a screw in the front of the gun. And even he said he's not an expert in firearms. He doesn't know if that means it's a real firearm or not. He just thought that it looked a little fancier than maybe some of the other replica firearms that he had seen in the past. So given those circumstances, our contention is that there wasn't even enough, especially with the comment new toy for the new beef, that this was a live working firearm. And so, I mean, as a practical matter, I'm not sure where we go with allowing officers to see a social media video of something that they don't even know is a live working firearm to go out and arrest people, which probable cause requires something more than suspicion, something definitive and substantial. And our contention would be that a video of something that could potentially be a toy firearm is not enough to go out and arrest someone hours later and charge them with possession of a firearm. And just to address the single justice order, I do address it in my brief, but our contention would be that the single justice's intent in allowing the Commonwealth's motion to deem the motion to reconsider timely was merely to deem subsequently the single justice application timely. She cited only to Jordan, which deals only with timeliness. Jordan says nothing about reviving waived claims. And it was just a procedural step to justify the long delay that the Commonwealth had made in filing their single justice petition. So they filed first, the motion to reconsider was late, which was something we argued in opposition to the motion to reconsider. And then the single justice petition itself was egregiously late. And so we had argued against both, saying that they were both untimely, and the Commonwealth, or the single justice's ruling deeming them timely under Jordan was merely addressing the timeliness, not actually reviving the claims that the Commonwealth waived below. So if the court doesn't have any further questions, I would rest on my brief for the other arguments, but we would ask that you affirm the trial court's order both on issues of waiver and also even assessing the merits of the case. The evidentiary hearing, the testimony at the evidentiary hearing made clear that Mr. Howard was arrested outside the vehicle at the time of the search, so it was not a search incident to arrest, and there was no probable cause to believe that the bag contained a firearm at the time of the search.
Check with the panel. Seeing no further questions, thank you both very much for your arguments. The case is deemed submitted. We are now going to take a brief 5-minute recess, and we will
And we are back live and on the record.
Okay, again, good morning, everyone. We're still at morning, yes. My name is Amy Blake, and I am joined by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel for this case and the rest of the cases that we're hearing this morning. Our next case is Barbara Russell doing business as Transaction Strategies et al. Versus Weiss Residential Research LLC. This is docket number 2020P0421. Attorney Rodriguez, when you are ready, you may begin.
Good morning. Thank you for giving me the time to set forth the argument of the appellate defendant, Weiss Residential Research. The issue before the court this morning is the trial court's memorandum in order of judgment dated November 19th, 2019. While I have submitted papers, I'm not going to recite the whole history of the case and the facts. I just want to highlight a few things. Plaintiff Barbara Russell wore 2 hats in her business relationship with Weiss Residential. She was an investment banker for BlackRock, and as the investment banker, she was looking to raise funds for a startup, Weiss Residential Research, which is in the index valuation business. In addition, and that document had a provision that says no funds will be paid until the first tranche or the first raising of funds. Then she entered a second agreement, which is really the core of this case and the core of the appeal. And that's where she provided, as she testified, cleanup services. She would come in, evaluate the corporate structure, the way the bookkeeping, the way it presented itself, and basically clean up companies before they raise funds. And she achieved this through an advisory agreement. And that is the crux of the appeal. And before I go into my argument, I just want to highlight a few aspects of that agreement. And that agreement
before
is,
you do that, counsel, I am a little unsure of what you are claiming. And the reason I say that is I read your opening brief as suggesting that the judge made some erroneous findings of fact. But then I read your reply brief to say, no, none of the findings are erroneous. Rather, the judge misapplied the law to the facts that he found. Could you help me to understand what?
yeah, I think it's, now I'm preparing for arguments, actually a combination of both, okay? I think the crux of it.
What was erroneous?
Okay, what was erroneous is that the judge said that the parties never considered what would happen if no funds were raised. Okay, that's part of his decision. And that is not exactly correct. If you look at Exhibit 5, it's the email just before the final agreement was drafted. It's an email between Rebecca Rabley and Barbara Russell. Okay, and in this email, Rebecca Rabley says, we're interested, I'm paraphrasing, but basically, we would appreciate if you agreed that the cost being covered comes out of the first raise. Cash out prior to that is not feasible for us. Okay, she's basically saying we can't pay until the first raise of funds. Okay.
So are you saying that there is no contract, or are you saying that there is a contract, but there's an ambiguity in the contract?
No. What I'm saying is that there was a contract, okay? And remember, she had the burden of proof in the contract, okay?
All right, so you saying there was a contract.
Right.
Do you say that there was an ambiguity in the contract?
Well, no, I contend that right from the face of the contract itself, it says the payment will not take place until the closing round of the first funding, okay?
She's not entitled to be paid for any of her work under that agreement unless they raise funds.
Correct, because that's how the other agreement.
Work for 6 months, do a ton of work, for whatever reason, raise no money, and she gets zero.
As drafted, it says, don't forget, she drafted this agreement, okay?
So wait, but stay with me. So
Okay.
If that's your position,
Right.
then why isn't there a valid quantum merit claim? If the contract doesn't provide for that, why should you're saying she was working for free?
I'm not taking the position. It was the court's position to say there wasn't a valid quantum merit claim. In fact, one of the
I'm asking you, you're saying that the contract did not provide for what would happen for her if they didn't raise funds.
Correct.
But you don't deny that she did work. So I'm trying to figure.
No one denies that she didn't do work.
Should she be compensated for that work?
Perhaps under a quantum merit, where there be testimony as to the value of the services and what she actually did. Okay, of course. I don't think I'm not disputing that, but that's not what the judge ruled.
There's not an ambiguity. You're saying they intentionally left out of the contract payment in the event that funds weren't raised, that there was no ambiguity in that regard.
Right, and to the extent, because the other contract says the same exact thing. It's an investment industry.
So there was or was not a meeting of the minds? I'm confused by your argument.
If my argument is, if the court says, the lower court, that there's nothing in there that we're missing a key term of this agreement, of what happens if money's not raised. Under the court's analysis, there's no meeting of the minds, okay? Because even under ICA, you have to have a meeting of the minds. You have to understand what you're obligated to pay. It's called mutual assent, as you
So
know.
if there's no meeting of the minds, there's no contract.
Right, and then we're back
But
at
when
the
I asked at the
quantum.
beginning, you said you're not arguing that there wasn't a contract. You see why I'm confused?
Right, because you got to remember, I'm arguing that there was a contract, okay? I'm arguing that there was a contract. It's not ambiguous. So when you look at ambiguity, you look at the term of the agreement. You don't look at what happens in the consequence under the agreement. You know, that's not I don't think the purview of the court. The court is, what did the four corners of the document say? Now, when it says until the closing round of funding, okay, and it says it twice, will come out of the proceeds. That's the court's examination. It's not the purview of the court between two sophisticated businesses to come and say, well, is this really the right thing that can happen? You know, it's not the court's role to play Solomon in this instance. It's the court's
Okay, so
obligation.
I want to really nail you down on this. Your
Okay.
view is there is a contract that is unambiguous, period.
Correct.
Okay,
Correct. Okay. Now, if you were to assume what the lower court said, and the lower court goes ahead and says, well, I don't feel that the parties actually addressed this issue of what would happen if the parties didn't raise funds. At that point, if we are to accept that statement, then there's no meeting of the minds under the court's analysis, okay, on the lower court, because you have to have a meeting of minds of the essential terms, and all the parties have to be aware of what they're supposed to do and what the consequences.
Harvard College says that even if it's an issue that the parties never considered, that doesn't mean that the court cannot supply a term that comports with fairness and policy.
Yes, but the point is, in the Harvard case, all the parties knew they had to pay, okay? There was no dispute between the parties that a payment had to be made. The dispute was whether or not, what was the amount to be paid? How were they going to base the payment? In fact, if you look at the Harvard case, if you give me 1 second, I will pull it up. If you look at the Harvard case, you know, the standard that the Harvard case and the other case that they cite, in the Fay case also, if you look at Harvard, and I'm looking at Harvard College, the case still looks at the intentions of the parties. What happens is, if a contract's ambiguous, okay, and a term is missing, it even says, I think in the case, similar to when a contract's ambiguous, the court can then look to the intention of the parties to determine what's fair, but the key term based on the intentions of the party. It's at 896.
The case says that it might have been a question that the parties simply never considered, which means you're not looking at the intent of the parties.
Well, this is a quote from the court. The court can look at extrinsic evidence, this is a quote, to give a reasonable construction in light of the intentions of the parties at the time of the formation of the contract.
Let me read a different part of the case.
Okay.
We recognize, however, that this may be a question that the parties simply never considered. Should the trial court so determine, that does not frustrate a sensible resolution. This is at the very end of the case.
Right, but here's the point. The parties did consider it because that was the email. You got to remember, the plaintiff has produced no evidence about the intention of the parties. Her only testimony is, well, you know, I thought it was obvious. I mean, we have the only evidence.
It seems like the email raises the same question as the language of the contract, which is, you know, the ambiguity in the contract is whether the language that this is going to be paid out of the first raising of funds is a condition precedent, as you argue, or whether it's just simply a provision that governs timing of the payment. And I think the email can be read the same way. And that's the ambiguity.
And who drafted the contract? She did. Okay, so if she drafted the contract, it should be construed against her. You got to remember, this is a woman who's been in the business for many years. She's part of another contract at the same time that says the same exact thing. Okay, that she would.
The judge found this wasn't something that the parties considered. So I'm going
Well, the
to
judges,
apply
I
a
mean,
term that
I don't
fits.
understand how the BlackRock agreement, which has basically the same sentence, you know, and says basically the same thing. They said they call it a tranche, executed at the same time in this industry, and then for the court to say that parties didn't consider. I think the parties did consider it. I mean, this is the industry, you know, how can
Counsel,
you
let me ask you
say?
this, Counsel,
Yeah.
I have two very specific questions. One, you reference a similar agreement with somebody named Kathy Raffaelli,
Right,
okay? Nowhere in the record on appeal do we have
right.
her.
And we cannot find that
You have
exhibit.
to let us finish our question. I
Okay,
know
I'm
that
sorry.
sometimes there's a delay on Zoom. Do you agree that that is not in the record appendix on appeal?
I couldn't find it. I have the transcript. We couldn't find the exhibit, so I'll strike any reference to that. Okay.
Okay. The
Okay, and I
next question is
apologize. We're
a fundamental question, because our rules require you to set out what the standard of review is on appeal. I don't see a section of standard of review in your brief. Your brother makes an argument about that. So can you just clarify for me, what is our standard of review?
sure. It's found in. I attach it in the reply brief because I addressed that in the reply brief.
Right, but in your opening brief, you agree that the standard of review is not set forth.
Well, I think the standard of view is the error of law. You know, he misapplied the law.
Are
I
we
mean,
reviewing this for abuse of discretion? Are we reviewing it for clear error? What are we reviewing it for?
we're reviewing for clear error of law in terms of. I don't think it's abuse of discretion. I mean, the case law is the case law. You can't, you know, I refer you to the RCI case. You can't rewrite contracts that the parties never intended to enter, you know, and I have a citation for a case like that. Yeah, you can add a term, but if adding a term changes what the parties intended, you know, you can't add that type of term, particularly here, the terms in which he was to pay, not the amount of payment like the other cases, but whether or not he is to pay. You can't rewrite contracts because it's not fair for her. I mean, these are sophisticated people. You know, she knew the industry. She should have drafted that she gets paid. If it's not, you know, and it was raised. I mean, it's right from the plain reading. You know, if she could easily added a sentence, well, if I don't raise the money, I get the funds. And that's on her, it's not on us to disprove that. It's on her to prove it as her burden of proof that she could have added it, you know, she thought it was obvious, but that's on her. You know, why should my client, who specifically said I can't pay this if the money's not raised, then be liable to pay when the money is raised? When the last communication before the signing of the agreement is I can't pay this if the money's not raised. And then now you like say, well, even though you didn't agree to this, we're going to impose this obligation on you.
All right, let me just see if the panel has any additional questions. Okay, seeing none, thank you very much, Attorney Rodriguez. Attorney Horstman.
Thank you very much. May it please the court, Attorney Rodriguez. I represent Barbara Russell on appeal, and it's our position on appeal that the judgment of the trial court should be sustained. I'd like to just take a few minutes.
Let me ask you out of the gate. Let's assume that we agree with the judge that the contract was ambiguous. Why shouldn't we construe it against your client, who was the drafter?
Because once you get into the essence of the facts here, it's clear that not only wasn't she the only drafter, but the facts are evaluated by the trial court in terms of what was reasonable. Let me start from the beginning. Barbara sent a draft proposal to Mr. Weiss that unequivocally said, I'm going to get paid $10,000 a month for my services. And what came back from his assistant, which is at Exhibit 5, I believe, is an email, Rebecca Ravely said, well, we don't, as you know, we don't have the funds for that right now. And that's what I would disagree with Mr. Rodriguez about. There was never a statement by anybody that said, we're never going to have funds if we don't raise them. There was a statement that we don't have funds right now. And what Barbara agreed to do, and this is clearly in the contract, is aggregate her monthly fees until the time that they both thought. I mean, that was the assumption here, the mutual mistake here, if you will, that both parties made, was that I think they're both positive, can-do, somewhat famous people in their industry. They both assumed this was going to happen. They both assumed funds would be raised. And for whatever reason, they weren't. There were some facts at trial as to why they weren't, but for whatever reason, and that was the mistake. So there was no clarification in terms of what would happen if no funds were raised, because the parties never really anticipated that. They both had great success in the industry. So I think it's fair what the trial court did was to pay.
Let's back up then to the question I asked your brother about the standard of review. Isn't the question of whether or not there's an ambiguity in the contract a question of law that we review de novo?
Absolutely.
Okay.
Absolutely. And the trial judge mentioned that in his findings. So
again, assume that we, for the purpose of this question, we agree that there was a contract, there was an ambiguity. How is the term that the judge supplied a reasonable one, as that's defined in our case law, where you just acknowledge that your client was aware that that the financial feasibility of Weiss really was risky? It depended on raising this capital.
Well, that's not exactly what the evidence of the case showed. The evidence in the case was that Barbara was told that this was an ongoing concern. This company was getting investments before Barbara ever arrived. There was an investor by the name of Kroll that had supplied an initial round of funding. So there was never a statement that there wasn't going to be any money coming in. There just was no money at the time that she was entering into the agreement with WRR. And as to the ambiguity itself, the case law is clear that silence equals ambiguity. So the fact that the parties never included a term in here one way or the other, that should not fall at Barbara's feet. Barbara clearly did not put in language that says, I will be paid no matter what. But WRR never added language that said, under no certain terms will Barbara be paid if she doesn't raise any money. Neither of those things exist in the contract.
Didn't you take a risk in a way by not cross-appealing on the dismissal of the quantum merit argument? Because it's possible that we could rule that there was no contract, there was no meeting of the minds, and then your quantum merit claim is gone.
I don't know if that would necessarily be true. I think where the judge, if you were to tip the judge's findings for, if you were to find that he was clearly erroneous in some capacity, I think it would then go back down to the trial judge to decide whether or not there was a quantum merit claim. Because if you found that there was no contract, then conceivably his finding with regard to the quantum merit claim is viable again. So I'm not sure the premise of your question is accurate, but suffice to say that either way, at the end of the day, there was plenty of evidence in the record as to what the standard in the industry was. As both parties have acknowledged, Barbara was in the industry for years. She testified that this was her standard fee. Under a quantum merit analysis, we would have asked for the exact same thing, and we did ask for the exact same thing. And that's what sort of the beauty of the judge's ruling is here. He did take a middle of the road approach. We had tried this case from extremes, both sides. The plaintiff, my client, took the position that this was fraud, that this was 93A, that his inducement to her and his refusal to pay were fraudulent and 93A. And Mr. Rodriguez took the position at trial that Barbara was taking advantage of a loophole in the contract. And what the judge said was, and it's clear, and it's sort of it's where all of the evidence ultimately flowed, is it was reasonable for Russell to be paid. This is page 8 of his ruling, page 66 of the appendix. It was reasonable for Russell to be paid for advisory services that she performed, regardless of whether WRR secured additional capital. The corollary to that was it was not reasonable for Russell to be paid conditionally for her advisory services to WRR and for Race Rock, because you have to evaluate those two things together. And I just want to clarify one thing that Mr. Rodriguez said at the outset, and it's not a misstatement of fact, it's just the way he presented his argument. The WRR Barbara Russell contract was negotiated first. It was signed on October 17th. The Race Rock agreement was signed on October 31st. So that he had the sequence off, and that's important because it's clear to Barbara that she's got to come in and she's got to be the house cleaner. She's got to clean up this corporation to make it presentable for other companies like Race Rock. Race Rock presumably wouldn't be the only one, but for other companies to come in and invest in it. And that's why you have the two contracts, and that's why she wanted to be sure that she got paid. And
so just to be clear, you think your view is there is a contract and there is an ambiguity. The ambiguity is when your client was to be paid.
I'm not disagreeing with Your Honor. I would phrase it differently. I would say
Tell me how you would phrase it.
The ambiguity is what happens if no money is raised.
Okay.
That's the ambiguity. And it's not addressed by either party. And I don't think it falls on Barbara entirely, because it was a suggestion that was made by Mr. Weiss that her payments be put off until the end. And this was the language that was agreed to. So you have two people in real time
Which is why you say we don't construe against your client. You say it was a negotiated contract.
Exactly. And it was a negotiated amendment to the term. And that's exactly what the trial judge found. And if Your Honors have no further questions, I'm content to rest on the brief at this point.
Let me just check. Seeing none, counsel, thank you both for your
And we are back, lad, and on the record.
All right, and good morning again. This is our final case for argument today. Once again, I am Amy Blake, and I am joined by Justice Suk-Young Shin and Justice MARYANN Walsh. Our final case is Guardianship of Child, docket number 20P1173. I remind counsel that the case is impounded, so we ask you to comply with the rules of impoundment. With that said, Attorney Kaiser, I believe you're the appellant, so when you are ready, you may begin.
Thank you. Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant child. And I am going to start by calling your attention to the affidavit I filed earlier this week, attempting to summarize events that have occurred since the parties filed their briefs in this matter. I think
Which
that
makes me wonder why this case is not moot.
Well, Your Honor, I would ask this court, notwithstanding the events that have happened below, to decide the substantive issues in this case. First, with regard to the child's direct appeal, my position would be that she is claiming that the deficient representation by her counsel led to an erroneous return of custody of her to her mother, and that all of the events that have come since that time flow from that erroneous determination. So in these probate court cases, of course, time does not stand still with children. And there's always, when cases remanded from the probate court, there will always have been new developments. In this case,
what would the goal be? Let's say we agreed with you, hypothetically, just for purposes of this question, and we say, okay, the child had the ineffective assistance of counsel. We're going to remand it. And Judge Elwick gets the case and says, well, it's now 2021 and there are these new actions. There's a case in Plymouth. There's a case here that I'm not taking any action on. What am I supposed to do with what happened in this case? Which is sort of the exact reason that I asked the question, why is this not moot at this point? She
Your
doesn't
Honor,
have the same lawyer appointed, right? I mean, if that was your concern, I would think, you could work with CAFL to make sure that she has a different lawyer in the trial court.
well, one of the problems, Your Honor, with the events that have unfolded since the case was briefed is that that the courts involved keep not deciding the substantive issues, right? And so I think this is a 12-year-old child who, like
Wait,
all.
what do you mean the substantive issues? Are you talking about fitness and best interest? I mean, clearly Judge Ulwick addressed that in this case.
In this case, she did. That's correct. But in the cases currently pending, both in Plymouth and in Essex, her status is somewhat in limbo. There's no date scheduled for a determination of what will happen to her until February 2022. So now that could change. Perhaps the parties can work something out, can take some actions in the trial courts to kind of straighten all of this out, and that would be great. But at this point, there is this pending appeal, which would give Judge Ulwick the direction that her initial determination that the child should be returned to the mother.
I guess I understand why you say the child's in a state of flux, and I'm aware of the termination of parental rights cases that address that concern. But as I understand your affidavit, and perhaps you don't like who it is, but it sounds like she is under the temporary guardianship of someone, and that there will be an evidentiary hearing of sorts in February of 2022. So she's not sort of just out there floating, if you will.
Well, in some respects, and I somewhat hesitate to get into all of the details and go beyond the record, but in some respects, even just with what I've stated on the affidavit, she's living with her uncle under a care affidavit, but that could change at any time because she's in the guardianship of her maternal grandparents, whose guardianship she strenuously objects to. And again, who, because they are her maternal grandparents, could conceivably return her to her mother, which would put us right back at square one.
All right, so perhaps we should move past, in view of the time, the mootness question, right, and get to the substance of your argument, because, and this goes to a concern I raised before we went on the record about who was going to participate in this hearing. Under guardianship of Tara, and again, I'm not reaching yet the ineffective claims, I don't know how we hear this appeal when grandma didn't appeal.
Okay, so I think it depends on which parts of the appeal that the court is referring to. With respect to the denial by the judge of the motion for relief from judgment seeking a visitation order, the grandmother did appeal from that. And she filed a notice of appeal in the trial court. And
was it docketed in our court?
I believe it was, Your Honor.
What's the docket number? Did she perfect her appeal?
Your Honor, my assumption had been that this was all docketed, so I would have to, I think, go back and look at the record and see, and I would have to supplement my argument here because I'm not prepared to answer that. It was my understanding that this was all docketed and on the record.
Is there something in the record appendix that you filed that would include grandmother's notice of appeal?
I do not, Your Honor, and again, I am not sure about that. So I guess you're catching me a little off guard.
I don't mean to, but I'm concerned because we've all operated under the assumption that grandmother did not appeal. At volume 1, record 40, I have the child's notice of appeal. I guess I need to look at the probate court docket sheet because I don't see any other.
And I'm looking at that right now, and it says motion for relief from judgment denied, and then notice of appeal by the child, and that's it.
And again, Your Honor, and I apologize for not having this information at my fingertips, and I can certainly supplement the record. I believe the grandmother filed a notice of appeal later, and and then sent notice to of her appeal to this court. But I guess I would prefer to nail that down and supplement my argument with a letter.
No, nobody, assuming that grandmother docketed her appeal, nobody has moved to consolidate the appeals. I would assume that would have been done had she filed an appeal.
That's possible, Your Honor. And again, I can't, you know, I'm in the difficult position of trying to explain what the guardian did and not what I did. So in that respect, again, if I could address the substance of the arguments, I think that would be the most helpful thing, and then supplement with a letter. In respect to the issue of the visitation order, assuming that the guardian did appeal, perhaps you'd want me to answer the question with regard to guardianship of, Tara first. I think in terms of the child's direct appeal, that case is distinguishable on a number of levels. First, the child's claim is an ineffective assistance of counsel claim, which is particular to her. Also, there's a lot of procedural differences between Tara and this case. First, that case involved a petition for guardianship, not the removal of a guardianship. And so when the guardian didn't appeal, there was no remedy for the court couldn't, you know, decide, no, that guardianship was wrongly denied, and so therefore we're going to send it back because the guardian hadn't appealed. In this case, these was a little bit different because it was the mother's request to remove the guardianship. But also importantly, in that case, the children had another remedy with regard to their placement. There was also a Care and Protection Act. So they had all of the procedural safeguards that a child would have with regard to their placement, including permanency hearings and review and redetermination hearings that they could have
But the child can participate in the pending case in Essex County, right? Am I misunderstanding your affidavit? There's a pending case, right, for guardianship?
There is.
There are two petitions in that case, right? There's one by the uncle and then one by the grandmother who's the guardian here.
That's correct.
Okay, so I guess I really just now do not see what relief we could order in this case if the guardian has a pending petition in a different county.
Well, Your Honor, I would say in this case, with regard to the visitation order, it is moot, right? Because the child is not in the custody of the mother right now. However, I do think the court has the discretion to decide that issue because it is an issue that is capable of repetition but evading review. And in fact, I think it's capable of repetition in this very case. And I think that the probate courts, I think this case is a good example of why the probate courts need some guidance in this arena. What you have in this case, now there's a long-standing rule in the probate courts that a court can grant visitation when the child's best interests call for it. The question that I think arose in this case was whether the court didn't do so despite finding that the child's best interests did call for it. In findings 148 and 150 to 51, the court stressed that that continued robust contact with the mother or with the grandmother was very important. Now, when the judgment was filed, or when the motion for relief from judgment was filed, the court found that its optimism with regard to whether the grandmother and the mother could work together didn't come to fruition. The mother almost immediately decided to cut off the contact between the grandmother and the child.
Not in the mother's custody right now, isn't that right?
Excuse me?
The child's not in the mother's custody right now.
That's correct, Your Honor. And so that's why I would agree that this issue is moot, and the question is whether the court decides to provide guidance to the probate court on this. Because what we
on what though? On the visitation, there has to be an open complaint to order visitation. You just can't pull it out of the sky. It has to be a grandparent visitation complaint or some kind of a complaint in equity or a petition for guardianship. A judge can't just enter a visitation order without an open complaint. That's the guidance.
Your Honor, I think that that the court did have the power at the termination of the guardianship proceeding to
so if she denies the guardianship and says guardianship dismissed, what is the open complaint that would allow her to enter a visitation order?
Well, the child filed a motion for relief from judgment, asking the court to grant a visitation order, and entered new facts that showed that the child was being denied visits with her grandmother, which was in direct contravention with the judge's findings that it was in her best interest.
The judge's findings, I don't know what's going to happen in that regard, but they almost seem like an exact blueprint for a Blixt-Troxel affidavit on a grandparent visitation case. It's like saying that a judge finds in the probate court, finds somebody not guilty of contempt for failing to pay child support and then says, but go pay the health insurance. You need an open complaint.
Your Honor, I think that in the probate court context, the Yeomans case is very clear. The court can even sua sponte, the probate court, when it's terminating a guardianship, can issue an order for visitation. What the child asked for here was for the court to revisit its judgment based on new facts and for relief from at least that part of the judgment in which the child was denied visits with her grandmother. So I think— Did the
grandmother plead visitation in the alternative on her guardianship petition?
She did not, and I think the question here is, well, what happens? I think if you look at all of the cases, the grandparent visitation cases, the probate court cases, the cases involving same-sex partners, they all focus on what is in the best interest of the child. And whether she labeled a motion correctly or not, the court has not just the ability, but the responsibility to protect the child's best interest. That didn't happen here. Now, perhaps the judge thought that the parent and the grandmother could work together at the end of this matter, but that didn't happen. And so sending the grandmother to another court, potentially because of the venue considerations of the grandparent visitation statute, when this judge had this case for 3 years and had already made findings with regard to visitation, I think was error.
Let me just check. I know your time has expired. We peppered you with some procedural questions. I want to make sure the panel doesn't have any additional questions of any sort. Okay, seeing none, Attorney Pack. You are still on mute. If you could unmute yourself. Thank you.
Again, good morning, Your Honors. I represent the mother appellee. Just to follow up on the visitation issue briefly, I think that the point that is missed by the child's attorney is, were this a case that went to a decree granting a guardianship, then other people who fall into line might be subject to visitation orders, just like in an open adoption case or something like that. But it's been my view on this case that given the fact that this was a petition for guardianship, it never went to permanent guardianship, and after trial, it was dismissed. At that point in time, the case went away. And consistent with Your Honor's remarks, I just believe that there's no basis to enter an order on a case that's been dismissed, number one. With regards to the paternal grandmother, it's interesting to note that in October of last year, she filed a petition for guardianship. Summonses were issued and presumably sent to her. And I went on, the mass courts again this morning just to double check. She never pursued it. The summonses were never returned, and the case was assigned to Judge Ulwick. And the two matters that are currently pending in Essex Probate Court, brought by the paternal grandmother and by the paternal uncle, are both assigned to Judge Ulwick. So, I think that on the issue, clearly the fear that some other judge might, be handling this, it would appear that the various parties, both in Essex and Plymouth, are of a mind, at least right now, that the child is better suited to be with the paternal uncle. I just found out within the past half hour that the Plymouth case, I think that there's been some lawyering, fumbling down below recently. There are some lawyers involved in these cases, but it appears that the last order that was entered in Plymouth was back on June 23rd by Judge Boyle, where he continued things to July 1st because it was brought to his attention that everybody was appearing before Judge Ulwick in Essex on July 1st. I found today that Judge Ulwick entered an order. She did not issue orders of appointment because it appears that she was operating under the assumption that the guardianship was still active in Plymouth. I contacted the virtual registry in Plymouth today, ultimately got to Judge Boyle's sessions clerk, and I believe that his order did not get extended beyond July 1st. So there's a lot of miscommunication going on here. But, assuming that the Plymouth case is being dismissed, there are two active cases in Essex, and I would
All right,
think.
so let me ask you to that point. There are at least two pending open cases in Essex, maybe an open case in Plymouth. Does that make this appeal moot?
I believe it does.
And your sister's argument that there's an issue that could escape review, I think these are my words. She said it much better than I will, but basically to give judges guidance that they can enter visitation orders. Do you think that Yeoman's changes my view that I've at least expressed in the questioning that there needs to be an open complaint?
No. And, to the other aspect of this appeal, which is the ineffective assistance of counsel, I would simply state that there was ample evidence, both testimonial and documentary, as to the struggles with alcohol of the mother, my client. And both, it came in through the temporary guardian, it came in through the mother. There was also substantial physical evidence supporting that, from DCF records that were voluminous to some police reports. And then with regards to the argument that best interest of the child was somehow not brought properly before the court, there had been a court-ordered waiver of the patient's psychotherapist privilege and volumes of records of the child's therapy sessions, including quotations from the child and expressed fears and concerns. That all came before the court. So even if, for purpose of argument, counsel for the child was doing a poor job of advocating for her client, the information was there nonetheless for the court to consider, and the findings reflect that. The pages and pages of findings by Judge Ulwick on those various points. So I believe there's no purpose to be served by the court taking any action on this. There are active cases down below. It's unfortunate that mother is in a bad place, apparently. I've been unable to reach her, so I don't know other than what I'm being told by people, but it's a sad situation. And but I'm sure that the matter will be handled. They'll figure out between Essex and Plymouth how to do this, and there are good judges involved to take care of the problem.
Let me see if the panel has any questions. Seeing none, I'm happy to take the rest of your argument on your brief. Counsel, thank you both for very good arguments. The case has been deemed submitted. Take care.